Don't tell me what the lawyer told you. That's between you two. Wait, ma'am, Ms. Hernandez, I'm going to find out who's lying to me. It doesn't matter to me who's lying. I'm going to, ma'am, I'm going to find out who's lying. You guys just make this hard when you do this, like with a handshake. If I went to a bank or I went to a dealership and bought a car, that's when I will execute a security agreement. I doubt that you had her execute a security agreement.
No.
Why'd you allege it in the complaint? Shh. Give me all your documentation. Did you ever sign a note at least?
We had this agreement that I gave you a copy. You should have a copy of our contract.
Okay.
And she resigned for the 2 payments that she did give me.
She signed?
She signed, yeah. The 2 payments, one on,
Oh, man, that's kind of telling, Ms. Hernandez.
and it says in the
You
contract,
guys come up here. Come on, get dressed. Come on up.
my mistake.
You didn't make a mistake. You don't have to apologize to me. You might be out when it's your burden of proof here. But I can tell somebody's lying, and I'm going to tell you who it is when we get here. Bring all your documentation, Ms. Hernandez, okay? That tells me that you paid this. Guys, I mean, you say you have a security, you filed a pleading saying you have a security agreement. Do you know what a security agreement is?
I was going by what
The
the
bank
banker told me to write down the,
name.
Cynthia Hernandez.
Why don't you come up here? I want you guys to resolve this. Did you buy a car from her?
Yes.
Did you
It's
stop
paid
making?
for. I have the title.
Hang on. Did you stop making the payments?
No, the car is paid for in full.
Is that true? Did she pay for it in full?
no, Your Honor, in the contract, it states,
Do you have a security agreement? I didn't sign did I sign yeah, I was concerned about this. You didn't have a security agreement, did you?
no, like my name was supposed to be on the title.
You guys, you try to be your own lawyers. It'd be like me. I don't care if she was your friend, not your friend. You guys you can't do things like this. This was a recipe for a disaster. Your name's supposed to be on the title of somebody else. When they're driving, you don't know if it's insured. They get in an accident, you get sued. You probably aren't going to have insurance on it. They're going to be coming after you. Ms. Hernandez,
Yes.
did she pay the payments?
No,
Good. Then
it was the last payment to be made on March 1st.
Well, what if she paid in advance? Did she pay in advance?
2 $500 payments.
Did you pay more than two $500 payments, Ms. Hernandez? Don't lie to me, because I'm going to get to the bottom of this. Listen to
Yes,
me very
I
quickly.
paid 2 on the day at the Secretary of
I
State.
didn't ask you that. Hang on a second. I want to be clear.
Okay.
I don't want anybody lying to me. And I'm going to find out who's lying. If she's saying it's not paid and you're saying it is paid, one of you are lying to me. So if you want to come up here with all your documentation and I'll try to resolve this for you guys right now, that would be fantastic.
On September 12th.
Hang on. I didn't say that. I didn't say anything here. Why don't you get dressed and come on up here? You live on Riverside, right?
Yes.
It's only a 6-8 minute drive at best. Bring all your documentation that tells me that you've paid for the car. How much do you think is owed?
2,000
How did she pay on the first 2 payments?
cash.
Nice.
Right.
Really good.
We were
Really?
together. She was living in my house.
Really, really, really good.
Yeah.
Did you give her a receipt?
Well, I wrote
Did you give her a receipt?
I wrote it in this book.
Did you give her a receipt?
No, Your
You
Honor.
guys, you know what? I mean, bring all your documentation up here right now, Ms. Hernandez. So you guys, she was supposed to put your name, keep your name on the title, huh? Did you sign did you sign the title over?
I didn't.
Why would you sign the title over before you? It'd be like you tell me you're gonna buy my house and I sign, hang on, blah. Well, then you should have talked to a lawyer. That's what they do.
Right.
That's what they do. I never sold it before. Come on up here, Ms. Hernandez. We're resolving this morning. Get yourself dressed. She's gonna wait, and you come on up here. How long will it take you?
Um, say, I don't know, 40 minutes.
I'll see you about 10 o'clock. Don't hurry, don't rush. I don't want you getting in an accident.
Right,
Take
right.
your time.
Okay.
I hope you're never gonna do something like this again.
Absolutely not.
Oh,
It's unfortunate.
this pains me to see this. It really does. I know it's only $2,000, but $2,000 is a lot of money. Bring all your documentation that shows me she paid you. You paid her. If you took cash out, you can go to the bank
I had
Wait.
cash.
here. But I'm telling you, I'm going to have you guys under oath and I'm going to resolve this today. And you guys are you're going to be honest with me because I'm going to find out who's lying to me. Okay. I'll see you whenever you get here, Ms. Hernandez. Unless you guys want me to adjourn this for a week or so, I'll be happy to do that.
Well, I'm volunteering today where I live.
Where do you live on Riverside? What do you mean you're
Yeah.
volunteering?
At the towers where I live.
Ms. Hernandez,
Yes.
why don't I do this? What do I have tomorrow, Jennifer?
Tomorrow is the 11th. You have Brownstown and Groseal reps. So let me see.
It's easy. All right, 8:30 in the morning. Can you be here tomorrow, Ms. Hernandez?
Yes.
Can you be here tomorrow at 8:30?
Yes.
We're starting at 8:30. Do I have sentencings on that docket tomorrow?
No, I don't see any sentencings at
Good.
8:30.
Perfect. 8:30. You guys be here. Don't make me wait. All right? I'm gonna
Okay.
adjourn. We'll set for February 11th at 8:30. Everybody's to bring any and all documentation. I'm gonna figure this out tomorrow. Have a good day.
Thank you, Your
Thank
Honor.
you. Thank you. Capital One versus Aaron Miller, 2504274. Can you do that and bring it
You know
down,
what? We may
please?
not have, no, you know what, Judge? We may not have done the actual order because we realized. I don't think we actually prepared it.
Do you have my copy by chance? Just my rough.
I have.
Just give us 1 second, guys. I'm
No,
so
not a
sorry
problem.
about this. This is, just give me 1 second. She's gonna try to find the old pretrial order. I didn't realize, I don't know if you know this, that's why I called the second pretrial, is because I didn't realize one of you had demanded a jury trial. So I need to have different dates. I need to change things up a bit. So just give us 1 minute and I'm going to go back and look at the other one and we will go from there. And if she doesn't find it in a minute, I'm just going to do a new one. I'll totally.
Yeah, Judge, I don't see that we never sent it out on our end down here. So I'm not sure if she did. Okay.
No, we got it. Perfect. Okay. So I'm going to call it again. It's Lynn Joseph Kaiser versus American Economy, also known as Safeco 2503197. All right, gentlemen, your appearances, please.
John Cooper appearing on behalf of plaintiff Lynn Kaiser, Your Honor.
Good morning, Your
And
Honor. Sagar Third appearing on behalf of American Economy.
Gentlemen, I didn't realize one of you demanded a jury trial, so I was wrong. So I'm going to give you new dates. I gave you, so we're going to have to change some of this. Are you guys still prepared to file your witness list by February 27th?
I can do that if you want, Your Honor. Yeah,
If
yeah.
you need more time, just tell me. I don't have a
Yeah,
problem.
yeah,
I
yeah,
just-
yeah. Why don't you just give us can you give us another 15 days on the 2 weeks on the witness list?
I'm not in a big hurry, guys.
Oh, okay. Well, then make it 30. And then
Give me 1 second.
okay.
All right, let's make witness list due on March the 27th. Discovery cutoff will be on April the 30th. I'll make it May 1.
Okay.
And we're going to give you a trial date. Same thing, no motions on the date of trial. All motions for summary have to be filed and heard not later than 1 day before the trial date.
Okay.
I am going to ask that you file a trial brief. So
Okay.
you do have to file a trial brief. Give me 1 second. And it has to be exchanged. Filed and exchanged not more than 7 days before the trial date. I don't need voir dire questions, but I am going to need jury instructions. We're going to give you, and they are going to be due 7 days before the trial date. Okay. So why don't you give me a date, Jennifer, in, let's see, May 1's discovery cutoff. I'm going to do a settlement conference on this one too. So, why don't you give me a date?
Judge, why don't we do settlement conference June 1st?
That's good with me.
And then we'll do trial June 26th.
Okay.
Settlement conference will do 10:30.
June 1 at 10:30. I don't mind if you guys appear by Zoom, unless you'd rather not. I don't think I need an answer to that, unless one of you want to say, I want to be there in person. So I'll let you do it by Zoom, the settlement conference. But I do want parties with authority to settle to be present, at least by phone. And the plaintiff counsel, I hope you'll have with you, okay?
Okay.
You said what day for the jury trial, June 27th or 6th?
June 26th at 8:30.
June 26th at 8:30. And I'm going to need you to file your jury instructions not later than 7 days before the trial date. Not later than 7 days before trial date. Okay?
Okay. Very good. And Your
And I'll
Honor,
have everything else set out here, so sorry about that. I just didn't realize anybody demanded a jury. So we'll get this out to you in the next couple days, all right?
okay.
Anything else, Mr. Cooper?
Yeah, I was wondering if you could put us into a breakout room for a minute, if that's possible. I guess I could call Sagar after this, whatever.
No, we'll put you in a breakout room. We'll do that right now. And if you if there's something you need to bring up after you talk, just chat with the civil clerk and she'll bring you back in the courtroom. Okay?
Okay. Very
Thank
good.
you.
Thank you.
Thanks. Let's see here. Okay, so I'm going to go over this with you. My notes aren't good, but I'll hand you those, okay? All right. Crown Asset versus Ian Adams, 2502599.
Hello, Your Honor. Hal Burke, P69068, attorney filling in for the plaintiff's attorney on behalf of Crown Asset.
Good morning, Mr. Burke. Who's here for Mr. Adams?
Sorry, excuse me. That's me, Your Honor. Ian Adams.
I'm going to need you to start your video, please.
Oh,
You
yes.
don't have a lawyer then, correct?
No, I know. I don't, sir. No.
You're going to have to take your hat off if you
Oh,
would,
yeah.
please,
Sorry
okay?
about that.
That's all right.
Good morning.
Morning to you. What's this case about, Mr. Burke?
Your Honor, this is an alleged non-payment of a collection matter, and Mr. Adams and I had a productive conversation before the case was called in a breakout room. May I give you that update?
Sure.
Thank you. He is working with a debt consolidation business. In fact, he mentioned to me he has another unrelated case that he's paying through them. I don't want to speak for him, but if you'd allow, and I have no objection, I believe he would like another 60 days or so to begin payment on this, which will resolve the case.
I don't care if whatever you guys want to work out, but I'd like you to. I'm going to be honest with you, Mr. Adams.
Yes.
Debt settlement companies, they move far too slow for me. Okay. And that's fine that you chose to hire one. I got no problem. But if you guys want to enter into a consent judgment or a conditional dismissal with payment terms, we get rid of the case. I don't care when the payments start. You want to go back in a breakout room and try to work all that out, Mr. Burke?
Your Honor, I think if you'd allow a pretrial in early part of April,
I know, but I've gone through that dance with the debt settlement companies. I could set one for April of 27, and I'm not sure that it would be resolved. So I just really, my preference is if you want me to adjourn it a week, I will do that. I don't have a problem with that. Maybe you can work out something in the interim. But debt settlement companies, it seems like I adjourn the pretrial and then I'm back there to square one. I don't want to do that. They're going to move at my pace. I'm not moving at theirs anymore. I mean, I'm sorry. I'm not a fan.
I agree.
They're not
with you.
lawyers and they have no sense of urgency. And I'm not talking about anyone specific. Just my general impression is there's no sense of urgency. So you guys want an adjournment a week or so, I'll do that. Otherwise, let's just set a trial date and we can go from there.
Your Honor, may we do the week adjournment and then he and I and the plaintiff's attorney and he can resolve it before then?
Yeah, no problem. I'll give you 2 weeks. Give me a date in a couple of weeks, Jennifer.
Yep, we can do February 24th at 9:30.
Is that good, gentlemen? February 24th at 9:30?
Yes, Your Honor.
Okay, that's what I'll do. And then hopefully you'll resolve it. If you don't, I'll just set it for trial on that date. Okay?
Okay.
Thank you. Thank you.
Thanks, guys. Have a great day. Thank you.
You too. Thank you.
Capital One versus Amy L. Potter, 2502765.
Good morning, Your Honor. Michael Spolman, P41216. And Judge, I'm of counsel for Buckles and Buckles today on behalf of the plaintiff for today's pretrial conference.
Okay, do I have anybody here on behalf of Amy L. Potter?
I have not had anyone check in, Your Honor.
Okay, counsel, I don't know if you saw this letter.
Yeah, I'm assuming, Your Honor, that you're referring to this. It looks like a letter answered dated November 26th of 25.
Correct.
Yeah, I read that, and looks like she's saying, yeah, I'm aware I owe the money. Always been my intention to pay. And then she describes some difficult circumstances that have made her unable to do so. It doesn't look like much of an actual defense there or anything that raises a factual issue, but I guess that's where we are, Judge.
Well, I mean, I wish she would have shown up. We could have entered into a consent judgment and I'd have been happy to set up an installment payment order for her, but she didn't show up here and I can't have that happen. I'm willing to give you a default judgment and hopefully your office will work with her and Jennifer, or Buckles and Buckles rather, and Jennifer, if she calls, you can invite her to file a motion for installment payments, but I mean, they still have to show up whether they have the ability to pay or not. And she's acknowledging she owes the debts. So why don't you give me the breakdown, if you would, as to how much is owed and your costs, and I'll go from there. How's that?
Okay, thank you, Judge. Judge, the principal sum was $18,326.57. The total cost of the filing service motion fees were $295.64. Judge, then there was no statutory or other attorney fee requested or included in any of those amounts. So the total sum they have on the proposed judgment they provided to me was $18,622.21.
Yep, that's what I got. Okay, 18,622.21 is the judgment amount. You can send that over or have them do that as soon as you can. We'll get rid of the case for you.
Okay.
Have a great day. Do you have anything else with me today?
Actually, Judge, I've got two more. I've got one more that was at 8:30, and then I've got another one with you, Judge, at 10. Just before we leave this one behind, though, Judge, did you want that submitted electronically by my file? Is that how court
Yes,
wants?
and file that, and they'll send it over to me for my signature.
Very well. I'll inform Buckles and have them submit that ASAP.
Perfect. Thank you. Do you have Capital One versus Huey then? Or no?
I have first. I have
TD Bank.
versus
TD
Brenda.
Bank versus Brenda Amra. TD Bank USA NA versus Brenda L. Amra, 2504518. Is Brenda Amra here, Jennifer?
She has not checked in, Your Honor.
I'll give you a default on this one. Again, I've waited 15 minutes. I don't default for 15 minutes, scheduled for 8:30. You can go ahead and proceed with your next default.
Thank you, Judge. But just something I should indicate for the record, I received a late communication from Buckles and Buckles regarding this one. They said that the heads up, Mike, the defendant has paid their settlement and we're waiting for the dismissal to be returned. So, Judge, it looks like, in fact, that we had a recent payment on this. And so rather than doing a default judgment, it looks like the dismissal submission of that to the court would probably be in order as soon as we get that.
Okay. She did answer the complaint, so I'm going to ask you to do a stip in order to dismiss, okay?
Certainly.
Stip in order to dismiss. Jennifer, put this one on again for February the 24th at the same time I set the last one.
At 9:30.
At 9:30, okay? So we'll put this back on the docket just to track it, and hopefully I'll have the documentation before then and nobody will have to appear. Okay?
Excellent. Excellent. Thank you, Judge. And again, my other one isn't till 10 o'clock. I've got the Capital One versus Dat Ha matter
Well,
then.
if they show up, Jennifer, you can call them in first, okay?
Yes. Yep, I will.
And I'll get so he can go on other business. Thank you. Have a good one.
Thank you, sir. You too. And I'll tune back in shortly before 10 if that's okay.
That's fine. That's fine. Absolutely. Capital One versus Thadius O. Huey Jr., 2504233. I'm sorry, 04223. Good morning, Mr. Huey. Your name?
Good morning, Your Honor. My name is Thadius Huey Jr.
And good morning, Your Honor. Kelly Sheehy, P number 89082.
Let me see here. What is this up for? Pretrial? No.
Yep.
Yes. Yes. Any resolution? Did you two talk?
We did talk, Your Honor. No resolution today, but I am confident that we will come to a resolution in the next 60 to 90 days. I would just be asking for discovery.
All right. Give me 1 second here. All right. So I'm going to give you, there's no ADR. I'm going to give you discovery until today is the 10th. I'll make it April the 10th. Witness list due March the 10th. No mediation. No settlement conference. I'm going to put down 1/2 hour for trial. Witness lists again are due on March the 10th. 26, you don't have to file a trial brief. If you choose to file one, it has to be filed and exchanged not later than 7 days before the trial date. I'm going to take a trial date from you, Jennifer. We can probably do this in early April. I'm sorry, early May. May the 10th or so.
Sounds good, Your Honor.
I gotta just wait for her to.
I'm here, Your Honor. I apologize. I had someone that was in the wrong courtroom.
No worries. May what? What do we want to do? I'm gonna look for one in early May.
Early May for a bench trial?
Yes.
4th?
Yeah, it's the day that my father passed away. You know that,
Okay, so you
40
want a
years.
different one?
Yeah, I do. I want a different
Okay.
date.
The 18th,
May 18th
and that would be at 10:30.
at 10:30 in the morning. And it is going to, Ms. Sheehy, give me 1 second here.
No problem.
Did you have a dad or a grandpa that was a lawyer?
I had a great uncle who was a judge,
Yeah, where was he a judge at?
47th District Court.
How long ago?
That would have been in the 80s and 90s.
Yeah, well, that's my I get it. That's what's happening to me. All right. I remember when I was in law school, this prof says to me, he says, Mr. McNally, I was in the Navy during World War II with your father. And I said, well, that was my grandfather. You should have seen the look on his face. Have a great day, you guys. I'll send this out to you. Mr. Huey, do you understand everything? Discovery is the exchange of information. If you want something from them, you put it in writing, requesting documents, or you could send out written questions, interrogatories. It doesn't seem like it's going to reach that point, but I do want you to understand that you have that right. Pretrial, I'm sorry, I gave you the wrong stuff.
Yeah.
That you're going to take that one. Okay, Mr. Huey, any questions?
I understand, Your Honor, and no questions at this time.
I wish you well. Thank you. Thanks, Michelle.
Yep, and I have 2 more at 10, I believe.
Yeah.
At
you
9, she's got 2 of them. The attorneys, opposing counsels are both present. She just hasn't had the opportunity to speak with them. I don't know if you
want to talk
want
to them. You have Capital One versus Stews and Capital One versus Vaughn.
Yes.
Do you want to talk to the lawyers, or you want me just to do a pretrial?
One of them
Mr.
is, I believe, is a motion for summary judgment, but we do have a consent judgment.
Okay, which one's that? Let me just call them. I'll call Capital One versus Charles M. Stews. 2501645. Mr. Syed, good morning. Your appearance?
Good morning, Your Honor. James Syed, P80407, on behalf of the defendant, Charles Stuse.
Ms. Sheehy, your appearance?
Good morning again, Your Honor. Kelly Sheehy, P number 89082 on behalf of Capital One.
Okay. John. Burns. Sketch. Hey, the button on my desk. Okay, this is a pre-trial. Did you guys resolve this one?
I am filling in for the attorney of record, Dylan Clark, on this matter, and it looks to me that there is a consent judgment. It just hasn't been executed at this point. So I guess I would just be asking for either permission to submit it under the 7-day rule or for defense counsel's permission to sign.
Actually, I had sent over the signed stipulation on February 5th, so Dylan might have that already.
Okay.
But you have my consent if you need to re-sign it.
Okay.
I'll just make a note then, parties reached resolution. Paperwork forthcoming. Can you get that over to me today, or have them get over to me today, Ms. Sheehy, and then I won't need to reschedule this.
Yes, Your
Okay.
Honor. Well, absolutely.
Thank you very much. Thank you.
Thank you, Your Honor.
All right. Do you have another one, Mr. Sayed? No. Okay. Capital One versus Vaughn, Christopher A. Vaughn, 2504221. Good morning, Mr. Apps.
Good morning, sir.
All right. You're on this one, right?
I am, sir. And your offer for a standard pretrial order is exactly what I would have requested. So unless the plaintiff attorney needs to spend more time with me, I'll get out of your hair and let you get some work done.
That sounds good to me too.
So we're just doing a pretrial. Is that right?
Yes, Your Honor.
Okay. Let me give you the dates real quick here. And this is, let me see, Capital One versus Vaughn. All right, so I'm gonna have witness list due. March the 13th, Discovery cutoff, April the 13th. Nobody demanded a jury, correct?
Not that I know of.
I don't believe so, Your Honor.
You don't have to file a trial brief. If you choose to, you have to file and exchange it not later than 7 days before the trial date. Let's see here, Mr. Apps. Let's see. I just want to make sure I get everybody to know who's here today. When we go to do these 89082 and Gary Apps, you are 46306, right?
Correct, sir. I was told they're
Okay.
going to add a 0 to all of our numbers to make room for the 100,000th lawyer, which is coming up, I guess, fairly soon.
It's amazing.
So I've had notices to appear with the 0 already added from some courts. See, my number is P046306.
Well, anybody who's got a 10P number would have to be at least 100 by now, wouldn't they? 95 or 90? I don't know.
I suggested to one of the judges we cut it off at 100,000, so we'd be like Bitcoins. Maybe we'd be worth something, but I don't think anybody's taken up my suggestion.
I got it. I'm going to give you guys a trial date. Why don't you give me one in May, Jennifer? That same date. Didn't we do May the 18th?
Yep,
May,
at 10:30.
May the 18th at 8:30. Okay. I'm sorry, 10:30.
Ready?
And I'm sure you guys will resolve it by then.
Absolutely.
All right.
Thank you, Your
Anything
Honor.
else? Anything else, anybody?
Nothing for me, Your Honor.
Nope,
All
spring's
right.
on the way. We're ready. Thank you.
Well, it's been tough. Today's a nice day, at least, kind of, relatively speaking. Have a good day, you guys. Thank you.
Thank you, everybody.
So I got this one here for you, Sadie. All right, Midland Credit versus Rodney E. Kellogg, 2502880.
Your Honor, I have not had either party appear, and we are in the process of calling plaintiff's office now. And that's the same for Capital One versus Miller. I have defendant in Zoom, but I don't have plaintiff here, and Jen's on the phone with that office.
So what you're telling me nicely is the babysitting continues, right?
Yes, Your Honor.
You don't have to answer that.
Jennifer, is Maverick Fence out there?
No, they have not. They're not on Zoom. That
I
one
got the
was
point.
scheduled to be in person.
I got the plaintiff in the courtroom.
Well, I'm going to wait about 5 more minutes for them. I give them 15 minutes. It's scheduled for 9. And then I'm going to call. Are you guys the Kerning? I'm not going to keep you. Do I have anything ready? Anybody who's showing up on time anymore? Except me, my court officer, and
Judge, I got a couple
Judge.
9:30s, but they're obviously not up yet. So
are they ready?
no. I only have one party.
What else can you go with 33rd District Court to have your case called early, huh? If one of them shows up, let me know. I'm not going to get off the bench because I'm not going to make these
okay.
people
And I
wait
have
here.
Gina's running down the judgment on that Maverick
Bernie.
Fence case because I didn't print one.
How you doing?
How are you, Judge? Are you done with these?
Just make sure I'm not putting it there. I'm gonna bad it up. Those things there when I come out here.
Sorry. I'll meet Gina halfway.
Okay. Any luck with the 2 lawyers on the 9 o'clocks?
Jen's still on hold. They're trying to find someone that was supposed to be in.
I never did collection work, but maybe those. Is there something wrong? Do you guys need more toner down there? I think you do.
Judge, yeah, it's being difficult.
Yeah, have Shane get more toner. If that's what we need. What is your name? Folks, what are your names?
Leslie Bowser,
Well, hi.
9:30.
Kerning Advertising, Agent Christine Walsh versus Maverick Fence, 2504871. Come on up to the podium, man. You had to come here all the way from Grand Blanc?
Yeah.
Jeez.
Thank goodness the roads were like this.
Jeez, I'm sorry, but I known we'd have let you appear by Zoom. Your name?
Christine Walsh.
Raise your right hand. You solemnly swear affirm and the penalties of perjury with the testimony you'll give in these proceedings will be the whole truth so help you God.
Yes.
All right, so what happened? Did you do some advertising for this fence company and then they didn't pay your invoice?
Exactly.
And was the total amount of the invoice 1905?
The total amount was 2205. He paid 300 of that, so the outstanding balance is the 1905.
And you still had a filing fee in this case of $70. You paid another certified fee of 18 for a total of 88. And they signed the certified mail receipt, correct?
Correct.
So that's the only out of pocket that you have?
Yes.
So the total judgment I'm getting is 1993, correct?
Correct.
I gave him 15 minutes. It's now 9:15. Defendant didn't show. I'm going to go ahead and grant default judgment in your favor. I would send them the judgment and wait 21 days, and then you can figure out whether they're going to pay it, or else you can go about collection proceedings. Okay, ma'am? You ever been through this process?
I have not.
It's not fun, but hopefully they'll pay it. If they don't pay it, then you can subpoena them for a creditor's exam. If you know where they bank, you can garnish wages, bank accounts of the defendant company. It's Maverick Fence, so you got to be careful. You can subpoena the principal of Maverick Fence, like the president.
Yep.
Okay, for a creditor's exam here at the court if they don't pay it. All right?
Okay. So after 21 days, if there is no response, what is my next step? To call back here?
Well, you're gonna have to kind of figure this out on your own. We can't really give legal advice, but you can subpoena the president for a creditor's exam here at the courthouse. And I'll let her appear by Zoom, Jennifer. I'll let them appear by Zoom.
Okay, no problem.
And if we get anybody, I know on small claims generally that I don't allow them to appear by Zoom because they always have documents, it seems, but if somebody's this far away and you want to give me a heads up, I'll look at the file and tell you.
Okay.
So yeah, you can subpoena him, you can ask him to bring, you can go online and see a lot of this, tax returns, where they bank, etc.
Yeah,
And,
Judge, if they use michiganlegalhelp.org, it does a lot of the question and answers on this stuff.
Okay, michiganlegalhelp.org. And you can go down the hall, we're gonna give you a copy of the judgment, all right?
Okay.
Thank you. Have a great day. Have a safe trip. All right. Is anybody ready on Capital One versus Miller?
She's on the phone still. They're getting someone on ASAP. Miss Miller is here. I do have both parties on. You have the parties in the courtroom. Miss Hernandez on that case is in Zoom.
Oh, yeah, we got the plaintiff in the.
Well, this is Capital One versus Miller.
No. The parties that are in the courtroom at 9:30.
Okay.
I have the defendant on Zoom.
Leslie Bolzager versus Cynthia Hernandez, 2504922.
Right here, man. Yeah, the phone.
Boy, you didn't do a very good job on this, ma'am. You can't be doing this. Your name?
Leslie Bolsager.
Who's here for Capital One?
Good
Your
morning,
Honor,
Your
we're still
Honors.
waiting for them to log in.
Judge, I'm actually present. I've been here since 9 o'clock. I had a breakout room with another defendant.
Oh, Miss
geez.
Francis, I apologize. I sent you a message to see what cases you were here on. I did not
sorry,
know
I
you
did-
were
have to
here on
start-
this one.
You have to start your video.
Oh, sorry, Judge.
Yeah, the
All
only
right,
case I saw you listed on my docket was for Spring Oaks, and when you didn't respond,
Oh, sorry, I didn't see your messages, and I was speaking with the defendant on my other file. I apologize.
All right, good enough. Good. I'm glad to know that you were at least here. That's good. Thank you. Your appearance, Ms. Francis?
Good morning, Your Honor. Sandra Francis on behalf of the plaintiff.
Ms. Miller?
Hello.
I need your name, please.
Oh, Erin Miller. I'm sorry.
All right. This is a motion for summary disposition, or did you guys resolve it?
No, Judge, I have not spoken to the defendant. I was in a breakout room with another defendant.
Will it help?
I mean, if she'd like to speak, I can speak with her.
You want to speak to her? Is this a credit card balance?
It is, Judge.
What is your defense, Ms. Miller? I mean, I know they've got these canned AI things going all over here, but what's your defense? Did you have a credit card with them and did you fail to pay it? Yes or no?
Yes, I stopped paying it.
Well, you stopped paying it, so you owe the balance?
I'm arguing that the balance is unconscionable.
Unconscionable.
Mhm.
Listen. All right. I love these A1 things. That's where you got it, all these lawyers out there that don't know, right? I mean, it's clear that you copied something. Unless you did, if
No.
you did this on your own, you missed the
did.
boat if you didn't go to law school.
I took the LSAT during the pandemic and decided not to go because the economy is so rocky. But no, I did that on my own. Yes.
Wait a minute. Are you telling me you wrote this yourself? You
I
didn't
did.
copy and
I
paste?
I copied and pasted some of as you can tell from the bench book, the civil proceedings bench book. I also used Google and I read a lot of court opinions, and I looked for a lot of different ways to support my
If
position.
you enjoyed doing this, maybe you should go to law school.
I'm still thinking about it. I took the LSAT, so we'll see. I'm going to take it again probably if I decide to go, but we'll see what happens. Law school is very expensive and the economy is not
If you
good,
did good
so-
on the LSAT and you did good in college, you might be surprised. They're giving out scholarships like they give out candy now. And that's a good
cool.
thing.
That is a good thing. Very.
I mean, it really is. Anyway.
Okay.
What do you want to do here? You guys want to talk?
Judge, I'm willing to speak
can
with
talk.
her.
Sure.
All right, go talk, see if you can resolve it. If you can, I'll hear the motion. How's that?
That's fine, Judge. I did resolve my other matter. Did you want to
What's
call
that?
that one for
Is that-
Spring Oaks?
Yeah, I'll call that one first. Spring Oaks Capital versus Gabriel Katrani, 2504421. Good morning, sir. Your name?
Good morning. My name is Gabriel Katrani.
All right. And Ms. Francis, your appearance?
Good morning again, Your Honor. Sandra Francis on behalf of the plaintiff.
What is the resolution on this case?
Your Honor, the defendant is currently making payments on this account. We've agreed to enter into a conditional dismissal. The defendant is making monthly payments.
You have a balance. One thing I don't want you to do, please. When I sign this conditional dismissal, it should reflect what the current balance is.
Yes.
I don't want to be ordering somebody in a conditional dismissal. I don't know why I'm getting some of these documents where I'm ordering somebody to pay something that they paid 2 months ago. I don't want to do that. So if you got a resolution, figure out what the balance is now, and you can just include that with any of your costs, and then you can have him pay whatever it is that you guys agreed upon going forward. Fair enough?
Yes, Judge.
Can you do that right now?
I can give you the current balance right now is
Yeah.
$19,223.85. He's made a total of $2,622 in payments already.
So, and how much is he agreeing to pay?
He is paying $1,311 monthly, and his next
$1,311 monthly?
Yes, and his next pay.
I got 10 a.m.
Go ahead.
His next payment is due February 19th and the 19th of each month thereafter.
All right. So right now he has a balance of $223.85. He's going to pay $1,311 monthly, has been, and will continue to. And his next payment's due on the 19th of February and the 19th of every month thereafter until paid, right?
Correct.
Perfect. So you're just going to do a conditional dismissal that reflects certain. If you want to put in there somewhere, defendant has already made payments and the balance is now $19,223.85. Part of the case.
Your Honor, but what was the paperwork that was agreed upon? I mean, it should be done by November this year. Correct me if I'm wrong.
Yeah, so the final payment should be November 19 of 2026 for $1,309.
Yes,
that should be your last
total
payment.
That total comes out to be around 15,000 something, right?
Wait a minute.
Did you? Because I don't.
How can the last? If he has a balance of $19,223.85, and he pays $1,311 a month,
exactly.
How can the balance be zero by November?
Sorry, when I spoke to the defendant, he had indicated, because he had set up this payment plan prior, he indicated he was making payments on the full balance, but you're saying there was a settlement for a lesser amount?
Yes, I'm sorry if I wasn't clear on that, Senator.
Okay. So then
settlement amount.
Okay, so
I have it on the letter.
Okay, so I just located the letter that was previously sent to you. So it looks like you did agree to a lesser amount of $15,730. Your initial payment was $1,311 on December 19th. Your final payment is $1,309 on November 19th.
So how are you going to reflect this now? You're not going to say there's a balance of $19,223.85 then, right?
No, Judge. It'll indicate that the defendant has agreed to make a settlement payment of $15,730. Will indicate the payments that he's made up to date, and then he will owe $1,311 on the 19th of each month thereafter until the settlement.
What if he misses a payment? What if he misses a payment? Is the original balance going to kick in, or is he still get the reduction?
Yeah, so the original balance kicks in, and we do give a period of time to cure the default.
Yeah, this is too dicey for me. It's okay, but I don't want to. It sounds like there's some unanswered questions here. I mean,
well, Judge, the defendant has agreed to a settlement amount, so we're going to honor that settlement amount. This was agreed to prior. He was trying to avoid a judgment, so I agreed to a conditional dismissal.
I don't have a problem with a conditional dismissal, but I want to make sure everybody understands if there's a conditional dismissal here, you're not going to reflect that the balance is $19,223.85 as of now, are you?
No, Judge, we would indicate that the defendant has agreed to pay the settlement of $15,730. In the event of default, the full balance minus payments made up to that date would be due and owing.
Are you going to send this to him? Do you want me to adjourn this? What do you want me to do?
So he's working with the debt settlement company, so we will be sending it to the debt settlement company. We've already sent the settlement letter. The defendant has already a settlement letter. And then we would send the conditional dismissal to the debt settlement
I'm
company.
adjourning this 2 weeks.
Why?
Because you want to know why? Do I have to bash debt settlement companies again? They move at snail's pace. And I'm not moving at a snail's pace. I'm not doing it.
What?
That's probably what happened. Well, counsel, when did you send the paperwork to the debt settlement company? When did your office send it there?
It looks like it was in December.
Yeah. Okay. Well, this is the middle of February, right? It's February 10th anyway. Why in the world would it take a debt settlement company 2 months to send back paperwork after payments are already being made? just creates a mess. And it happens-
I did.
and-
Real quick,
I'm not
Judge.
trying to argue with you, Mr. Katrani. I just know what happens with debt settlement companies.
So I handle it personally. With this one specifically, I'm calling Weber and I'm having them do the payments literally while I'm on the a group call. So it's being handled as far as that goes. I was just waiting for. So whenever I call Weber, they're like, okay. And I spoke to Sandra. She said, regardless of an agreement, there's still going to be a court. We want it settled in court. That's what I was told.
From the debt settlement company.
Sandra just told me that 10 minutes ago.
No, Judge, what he's trying to say is, despite the fact that he agreed to a settlement, the lawsuit was already commenced. So we told him we're going to proceed with the lawsuit.
Okay, am I missing something? And I don't
So
want.
I was served
Mr. Katrani,
document.
I get it.
Yes.
I get it. I'm talking to the lawyer now. Just give me 1 second, if you would.
Yeah, Judge. So it looks like he agreed. I wasn't involved in this, but it looks like he agreed, or the debt settlement company agreed to a settlement on his behalf back in December. But I don't
Why didn't they sign the? Why didn't he or somebody sign the paperwork, and then you could file a stip in order to dismiss or a conditional dismissal as you are back in December? That's all I'm saying. And then I had payments made, and then I've got you here, in no disrespect, Ms. Francis, but you're telling me initially the balance was 19,223.85. That's what you told me. And you said it was 1311 a month. And now he's telling me he's going to be done in February, so we've got a balance that's 4,000 less. I don't care how you guys do it. Now he doesn't want me to adjourn it. I don't feel
I
comfortable.
really don't. I want to get this settled.
Wait. Please listen.
Yes.
This is too. If you're going to handle the paperwork and not the debt settlement company, maybe I've just got a bad notion. I mean, debt settlement companies, are any of them lawyers, Mr. Katrani?
So they've been really good.
Are any of them lawyers?
No.
Okay. Well,
really quick, Judge.
I got a fundamental issue with the fact that they're sitting out here like a center fielder in the bleachers somewhere.
Yes.
And they're sticking their nose in civil litigation. And honestly, there's only one or two people that can represent somebody in a court of law: a lawyer or the defendant, period, or the plaintiff. You can appear in pro per, corporations can't, but that's another story. So I've got this other player out there that's not even licensed to practice law, and they're involved in this, and it just clogs dockets and makes things more complicated. You guys tell me what you want me to do. I'll either adjourn it 2 weeks with the hopes that we'll have it back, the paperwork, or if you want to put all the terms on right now, and he's going to agree to let you sign his name to the proposed conditional dismissal, or if he wants to review the paperwork himself personally before agreeing to it, I don't have a problem with that. So you guys give me, there's three options: adjourn 2 weeks.
Yeah, the second option is good.
What's that?
I want to get this done and over with. I've been paying, and this is so just the timeline as far as you saying they move like snails. I was served the documents in December. They came to an agreement end of December 19th. Payment was made December 30th. They work quick. And the only reason I have them involved is so they could be a little more credible as far as holding the money. Like there's an account that they hold the money in.
Counsel, put the terms on the record, exactly what it's going to say.
Okay. Your Honor, the defendant has agreed to pay a settlement of $15,730 in monthly installments of $1,311. The defendant has made 2 payments on the account. The payments were made, sorry, it's got to click to that screen. The first payment was made on the account for $1,311 on December 30th. A second payment was made for $1,311 on January 17th. Defendant's next payment will be due
We
on
know, the
February
19th of
19th of-
February, 1311 per month until paid in full, with the last payment being 1309 and some odd cents in November, right?
Yes, and in the
And
event
then
of,
where are you gonna, what language are you gonna have in there as to what happens if he misses a payment? Besides the fact that you're gonna file an affidavit of non-compliance and this would convert to a judge, you're gonna have that language in there, right?
correct.
Okay, and then, go ahead.
We will provide the defendant with an opportunity to cure that default within 7 days. If he cures the default, the payment plan will continue. In the event that he fails to cure the default, the dismissal will be set aside. A judgment will enter for the full balance due and owing minus payments received.
And what's the full balance due and owing? Are you going back to the
Currently,
19th?
yes. Currently, the amount is $19,223.85.
Okay, so you understand that, Mr. Katrani, that if you miss a payment, this is going to convert to a judgment. And,
Yes.
and you're going to owe the 19,000 and some odd dollars instead of the 15,730.
And previous payments will be credited.
Correct.
Yes.
Which is correct. If you miss the last payment, they're going to enter a judgment for 19,000. How much, Ms. Francis?
$19,223.85.
Less all the payments made, as opposed to the 15,730.
Yes.
Now, are you comfortable, based on what you've heard, allowing her to sign your name to a proposed conditional dismissal, or do you want to see the paperwork?
Yes, I'm comfortable.
Okay, so she has your permission to sign your name to that document, and she's going to submit it, right? And you're comfortable with all that? I just want to make sure.
Yes. Thank you, Judge.
Okay. I'm not trying to give you a hard time, believe me.
No, I know.
Okay. Ms. Francis, so you're going to submit that, and we're going to be all set then, right?
Yes, Judge.
Thank you very much. You're all set. Best of luck
Thank
to you,
you, Judge.
sir. Thank you. All right. Now you're going to go talk to Aaron Miller, right?
I'm just
Yes.
getting her in now.
Take your time. I got a couple others here, so I'll be able
Okay.
to. LVNV versus Parker. Is anybody here on that?
Judge, they are in a breakout room still. They've been in there
Okay.
for a little bit.
So what else do I have ready here?
Midland versus Kellogg. I've got an attorney, Dylan, logged in. I'm going to bring him in. He's not answering my message.
Hey, no, that's Mr. Dillon. He's not on that. Mr. Dillon, how you doing, Mr. Dillon?
Morning, Your Honor. I'm well.
You're not here on Midland Credit versus Kellogg, are you?
No, we had Twardzik, but the case has been dismissed. Check's been cashed.
Oh, yes. Yes,
I
we did
signed that
receive
order
that.
yesterday.
Yeah. God bless you.
Have a good day. Thank
See
you.
The next go. Thanks.
All right. See ya. Do I have Midland Credit, Ms. Osco, then out here or no?
No. And we've called and left a message at their office. Defendant did not appear as well.
Yeah, see, you would think. You'd think they'd at least call and give us the courtesy of that, wouldn't you? I'm going to go ahead and dismiss it. He didn't appear. She didn't appear. We called. It's 45 minutes late. Case dismissed. Do it without prejudice. Just do a regular order, failure to appear. Both parties dismissed without prejudice. Okay?
I will type that up.
Thank you. Do I have anything ready here? What's your name, sir?
They're here at 10 o'clock.
Are both parties here for the 10 o'clock?
There's only one. Even what? I don't know if we want to take that either.
Well, not if I only got one.
Yeah.
Is that Fanton Ha here, Jennifer? I thought I saw the name out there. I could be wrong.
I don't have plaintiff's attorney back, but
Right.
yes. So I'm waiting for plaintiff's attorney to come back, Mr. Spellman.
So I'm kind of at a standstill here, right?
Yes.
All right. Okay. Okay, Capital One versus Miller, 2504274. Good morning, Ms. Miller. Again, your name?
Good morning, Erin Miller.
Ms. Francis, good morning, your name?
Good morning, Your Honor. Sandra Francis.
Any resolution on this?
No, Your Honor.
No.
All right, you can go ahead and argue.
Your Honor, just briefly, our motion is brought pursuant to MCR 2.116C9 and C10. Defendant had entered into a credit card agreement with Capital One on March 1st of 2004. The last payment made on the account was February 19 of 2024 for $150. The account was then charged off on July 29 of 2024. The defendant utilized the card, made payments for a period of time, and then defaulted. As set forth in our motion, the defendant has failed to provide any viable defenses to our cause of action. Therefore, we're requesting that the motion be granted today.
Ms. Miller, what would you like to say?
I would like to say that I did present many valid defenses in the first place.
I want you to outline.
Okay, absolutely. So in the first place, the plaintiff has failed to show any proof that I ever used the card. The only transactions that they included in the evidence was the time that they took $500 out of my bank account without my knowledge or permission, and I had to dispute it with my bank and have it returned. The card, their evidence goes back to 2023, I believe. It might be 2022. They've showed no use of the card during that time.
Hang on one second. Jennifer, do I have all the attachments on this? Jen Weisman?
Yes, Judge, I'm looking.
I'm going to let her look, and I'm going to let you go
Yeah,
ahead.
I've got a number of exhibits, Your Honor, that were
How many? How many pages?
63, 66, 70. It's like 5 different, so it's close to 100 pages.
I'm going to let you argue, Ms. Miller, and then I'll come back to you, Ms. Francis, okay?
Okay.
Go ahead. I'm sorry, Ms. Miller.
Oh, no, you're fine. The plaintiff obviously moved for summary disposition, claiming that I failed to state a valid defense. I'm arguing that I did state several valid defenses.
Tell me what they are.
Okay, so there are genuine issues of material fact in the case.
That's all. Okay, tell me what they are.
Yep, okay. So there, on the first count, the alleged breach of contract, there is no written contract. I don't know.
You need a written contract to form a contract?
You don't, but there has to be a decision made whether there's a written contract, which the plaintiff does allege in their motion for summary disposition.
Use of a credit card that's been authorized, does that create a contract?
They've shown no proof that it was used.
Did you show any proof it was used, Ms. Francis?
Your Honor, yes, we've attached several credit card statements. And from speaking with the defendant, Your Honor, the defendant seems to be upset about the interest charge on the account. She indicated
Don't blame her. I'm upset about the interest charges. The only problem is I don't have any authority to start creating my own law here. How much are you charging? 29%?
About that.
I was laughing at one of the, I'm not going to mention names, but somebody say, wow, then that's going to disqualify people that don't have good credit if we have to lower the interest rate to 10% as they discussed. And I thought, really? Well, so, I mean, that was the most ridiculous argument I've ever heard. You get to charge whatever you want and lure people in and create bankruptcy situations or take their money, and that's just ridiculous. But ma'am, I don't have any authority. I knew that's where you were going from what I read. I don't have any authority to change the interest rate.
Right, but I am arguing the unanimous Supreme Court decision under Quintero, which requires the Barnett test to be applied to any case that is arguing sort of what I'm arguing, that this interest is unconscionable because it exceeds Michigan's 25%.
No, but it's not governed by Michigan law is the problem.
But I am arguing that it is. So under Quintero, if we apply the Barnett test, according to the Frank-Dodd Act.
What is your interest rate, Ms. Francis, on this card? I mean, Ms. Francis, or Ms. Miller, I don't disagree with you. I think it's horrific. I think it's horrendous. I don't like it. I think it's unfair. I think it's unconscionable. But I need
It looks
law.
like it's at 27.9%.
That's all? 27 point what?
27.9%.
I think there was a higher one in there.
It doesn't matter if it's 27 or 29. They're all about 3 times too high, in my opinion.
So my argument, oh, sorry.
Go ahead.
Okay. So my argument, when we apply the Barnett test, as required by the Frank-Dodd Act, and we look at MCL 438.41, which sets the criminal usury rate in Michigan at 25% simple interest per annum. There's absolutely no way that applying the state law in this case would prevent or significantly interfere with Capital One's ability to do business in Michigan. State banks seem to do just fine operating under the criminal usury rate. And there's no discrimination, which is another part of the test under Quintero. And so I think when we take those two things into consideration, Quintero does apply here, and you do have the authority.
To limit them to what? To just strike out all the interest whatsoever, or what?
No, Michigan sets the criminal usury rate at 25% simple interest per annum, and that is per MCL 438.41, which is Act 259 of 1960.
So you're just arguing a difference of 2.5%, roughly 2.9%. You understand that, right?
I do understand that, but that adds up over 20 years. This was an account that was opened 5 years before the Card Act of 2009 was passed. And that was passed by Congress because they were seeing what was happening to my generation, that we were being preyed on.
Yeah, I know. I've been saying this for 20 years, at least 25 years, I think. It's ridiculous. Can you do anything to help her out on that, Ms. Francis?
Your Honor, I can't agree to waive all the interest over, but I did offer her if she wanted to discuss a settlement. But the settlement that she offered was not something that I could accept. I mean, if she's willing to discuss a reasonable settlement amount, I can definitely.
I don't want to know
that.
what your settlement amount is. I don't want to know what offers there are. You're saying you agreed to waive all interest?
No, I did not agree. She was seeking for me to waive all the interest, which I could not agree to. So I offered to discuss a settlement for a lesser amount. And the settlement amount that she offered was not reasonable for the amount that's owing. So
can you tell me what the total amount owed that you're seeking, Ms. Francis, is?
Yes. So the total amount owing right now is $5,098.69, Your Honor.
Why don't you two go back in a breakout room and try to talk about this again? Otherwise, I'll rule if you can't resolve it. Sometimes, Ms. Miller, we might be right in principle, but we're wrong in the law. I mean, I don't like this either. I'm being completely candid with you. I've said this many times. And I just think it's horrible. I really do. 27, 29%. I mean, but some people are so irresponsible with these. And I'm not saying you were one of those, but they can't get a credit card unless they're willing to pay that. And that's what they're going to charge because they can. And state law does not govern this. I wish it did. And I wish the cap was at something reasonable. We'll see if Congress has the wherewithal to act. I doubt it. But we'll see. I'll be shocked if they do. They should have done it decades ago. You go ahead and talk in a breakout room, ladies. See what you can come up with, okay?
Okay.
LVNV versus Tory Parker, 2500558.
Good morning, Your Honor, and I'm Jack Francis on behalf of Plaintiff's Attorney of Record.
Good morning, Ms. Francis.
Morning, Your Honor.
Do I have Ms. Parker? I'm looking here.
Yes, good morning.
Oh,
Your
I'm
Honor.
sorry. I'm sorry. Your name?
Tory Parker.
Your Honor, we did. Sorry.
Yeah. Go
We did
ahead. Go ahead.
We did discuss the matter. Ms. Parker wants to discuss the matter with her attorney and also we needed some more information from her to connect the dots for what she is claiming. So we both agreed if Your Honor would allow a 30-day adjournment.
Why didn't you show up last time, Ms. Parker?
I was telling you last time I was there, Your Honor, I have a lot of neurological injuries, memory problems. I have a lot because I was injured on the job. I'm still under specialist care right now. So I don't know how.
How long do you need, ma'am? I'm sorry.
30 days, Judge.
All right, we'll adjourn this to March, Jennifer.
17th.
You got to come up
That'll
with
be
that
in the afternoon,
documentation, though, ma'am. It's going to have to be right after I get back.
Your Honor, when I came in the first time, I brought in a check. They wanted bank statements. I brought that in, and now they're saying that's not good enough. So I have to figure out, I guess, what it is. She told me kind of what I needed, so I'm going to try to get it from my attorney.
I told you to provide 1 month of bank statement.
I did.
That's what I said. Did she give you a month of bank statements, Ms. Francis?
Judge, she gave us parts of the bank statement, and all the bank statement said was deposit. And then the check is from a company that's not related to workers' comp, which is what she's claiming. So she said she would get a statement showing what the check was for.
So you need to provide proof, ma'am. You need to provide proof.
Your Honor, I brought in,
Ma'am, just listen to me. You need to provide proof that you did not commingle these funds with other funds. Are you with me? If this is just workers' comp funds, you have a point. If they're not, then you don't. You understand what I'm saying?
That's why I brought in the bank statements. And I think it was just one page because it looked empty. It's nothing on the page. And that's the one I took out. But I showed it to her today. And so she saw the pages that she said weren't in there. She saw them today, and she doesn't even want that. She wants something totally different from the bank statement. She says something. When I look up Sedgwick online, she looked it up. She says she didn't see workers' comp. I have it right here, and it says nothing but workers' comp when you pull it up online. So now she wants me to prove basically that Sedgwick was workers' comp and that these checks are workers' comp. I mean, it says Sedgwick on a check, but she says she can't find Sedgwick under workers' comp.
Go to the bank, go back to the bank, and ask them to type out a statement that these are the number of pages in that monthly statement. You bring 1 month of bank statements, like I told you, and then there's no question about it.
Well, that's
Judge,
what she has, Your Honor.
There's 2 checks that she's deposited, and so she just needs to show. The letter she showed was that it was for a medical refund for one of the checks. So we need just some connection that these funds are from workers' comp. She hasn't shown that the checks are from workers' comp.
I showed her the letter, and the letter says work-related injury. And I showed her the letter from the attorney explaining what it was from, and it says on the letter work-related injury.
Well, I don't know. You guys are saying what you sent her, and I don't have a copy of any of these. Can you send them to me, whatever it is you
Yes.
gave to them?
Yes.
Send them to us so we can have them part of the file, and I'll have them in the file when you return.
Okay.
She also didn't send it, Judge. She just held it up to the screen today. So I asked her to send us copies too.
Send it to her too, ma'am. Send it to her too. 1 month's worth of bank statements. That's what I
Yes,
asked you
ma'am.
to do.
Yes, I brought them to the court and they took I don't know
We
how.
do have, Judge, we do have some bank statements that she brought in. I thought they were printed and put in the back of the packet, but maybe we missed printing them.
All right. Well,
Judge, we would just need connection that it's workers' comp.
yeah. So you send those to Ms. Francis, Jennifer, and you don't have to do that, Ms. Parker. We'll send you Ms. Francis.
We did get those bank statements. It's just there's page 1, then page 3, then page 5, and there's pages missing. And then the deposit just says a large deposit. It doesn't show what it's from. And there's 2 checks. There's 2 different checks that she deposited. So we need the proof that this is workers' comp payment, Your Honor.
Yeah, I'm looking at the back, Jennifer. I didn't realize I had those. I had page 1 of 7, then it says 3 of 7, then 5
Yes,
of 7.
that's what we received.
Then 1 of 5, 3 of 5. So we don't have them all either. 3 of 7. You have to get, they shouldn't say 3 of 7. Where's 4? Where's 2? You got to get us the appropriate ones. You need to bring those up here. We're going to reschedule this.
Okay.
Okay, but you got to get us all the documents. I understand what she's saying now. Give me a date in March.
The 17th, but that would be at 1:30 in the afternoon.
Okay.
Thank you.
What's my docket that morning, Jennifer?
Could we do this in person too, so we can just see everything
I would
as
love
well?
that. Yeah, come in person. Both parties to be in person. Jennifer,
You've
do I
got
have
probation
something
and
going?
department reps that
Okay,
morning.
good enough. 1:30 in the afternoon. I'll start promptly, okay?
Thank you.
Thank you, Your
All
Honor.
right. Have a good day, you guys. Thank you.
too. Thank you.
you.
Capital One versus Miller, 2504274. Ms. Francis, your name again, please.
Good morning again, Your Honor. Sandra Francis on behalf of the plaintiff.
I need you to start your video. Ms. Miller, your
Sorry,
name.
Judge.
Good morning, Erin Miller.
Any resolution?
What if a man accused of DUI wasn't acting because of alcohol at all, but because of a medical condition nobody could prove? That was the question hanging over this courtroom as Bobby White stood trial. Prosecutors argued the case was simple. They said Bobby was operating a motorcycle with a blood alcohol level well above the legal limit. Officers testified that alcohol impairment was present, and the state insisted the evidence clearly supported a DUI conviction. But the defense told a completely different story. According to Bobby's fiancée, she had witnessed seizure episodes during their 9-year relationship. She described frightening moments where he would become disoriented, forget where he was, fail to recognize family members, and struggle to understand what was happening around him. She testified that after these episodes, he often suffered severe headaches, sensitivity to light, body pain, and even injuries from biting his tongue. The defense argued that on the day of the motorcycle crash, Bobby may have suffered a seizure before getting on the bike. They pointed to unusual details. A Father's Day meal was being prepared at home. A pork shoulder was still cooking. Dogs that were normally separated had been left unattended. The defense claimed these actions didn't make sense for someone thinking clearly and suggested they were signs of confusion and disorientation. However, prosecutors pushed back hard. They reminded jurors that there was no medical diagnosis presented proving Bobby had a seizure disorder. No doctor testified that a seizure occurred that day. Even Bobby's fiancée admitted she wasn't present when the crash happened and could not say for certain what caused his condition afterward. The state argued that speculation could not replace evidence.
A courtroom battle over credit card debt took an unexpected turn when the judge openly agreed with the defendant's frustration, but still wasn't sure the law was on her side. The case involved a woman fighting a collection lawsuit tied to a Capital One credit card account. She argued that the company had failed to prove certain elements of its claim and challenged whether a valid contract even existed. According to her, there were genuine disputes about the facts that should prevent the court from immediately ruling against her. As the hearing progressed, the discussion shifted to something that instantly caught the judge's attention: the interest rate. The defendant pointed out that the account carried an interest rate approaching 28%. She argued that such a rate was excessive and unfair. She cited legal authorities and attempted to convince the court that Michigan law should limit what the credit card company could charge. According to her, consumers were being trapped by massive interest charges that continued growing year after year. Then came the moment nobody expected. The judge admitted that he personally hated seeing interest rates that high. He called them ridiculous and said he had been complaining about similar rates for decades. He questioned the fairness of allowing companies to charge nearly 3 times what he considered reasonable. For a moment, it sounded like the defendant had won the judge over completely. But then reality stepped in. The judge explained that courts don't decide cases based on personal opinions. They decide them based on law. No matter how strongly he felt about the issue, he couldn't simply rewrite federal banking regulations or create a new interest rate cap from the bench. His job was to apply the law, not invent it. The plaintiff's attorney responded by presenting account statements and evidence showing the debt balance.